Good afternoon, ladies and gentlemen. Welcome to the 8th Henry J. Abraham Distinguished Lecture to be delivered today by U.S. Supreme Court correspondent and Sandra Day O'Connor biographer, Joan Biskupic. I'm Barbara Perry. I'm the Executive Director of the Virginia Law-Related Education Center here in the Commonwealth. And in my capacity as chair of the Abraham Lectureship Steering Committee, I want to welcome you this afternoon and offer my profound thanks to those many of you who have made this lectureship possible. Some of you offered inspiration as well as support, which remains ongoing, for a lectureship in Henry's honor. Many of you, friends, family, colleagues, and former students of Henry, contributed generously to help us fund the lecture's endowment in record time. Fundraising for such a beloved teacher and scholar as Henry Abraham was the easiest task I have ever undertaken in the academic world. Our grassroots effort on his behalf garnered not only financial contributions, but warm letters that invoked memories of Henry's impact on undergraduate, graduate, and law students from Penn to UVA. And Henry has developed a new following here in Charlottesville among the alumni of his popular and oversubscribed Jill course, sponsored by the university's lifelong learning program, and some of you may be alumni of that course. This academic year, because of its popularity, Henry is offering 2 sessions, one last fall and one coming up this spring. An example of Henry's continuing commitment to teaching is that his performances are strictly pro bono. His student evaluations, however, in this pro bono course are as laudatory as those from his days of full-time teaching and would be the envy of any tenure-seeking professor, as would be his authorship of 11 books and more than 100 articles. Henry, who is the James Hart Professor of Government Emeritus here at UVA, continues to research, write, and lecture far and wide, from the U.S. Supreme Court last year to Trinity University in San Antonio, Texas, this coming week. He has received the highest recognition from this university, UVA, that is the Thomas Jefferson Award, and the highest recognition from the American Political Science Association's Law and Court section, that is its very first Lifetime Achievement Award. I refer all of you to the synopsis of Henry's brilliant career in the brochure you received at the door. And now I will ask Henry to stand and be recognized by our visitors today. We are honored indeed this afternoon by the presence of some of our past Abraham lecturers, Professor Tinsley Yarborough from East Carolina University, General William Souter, Clerk of the U.S. Supreme Court, and I know we're due to be visited by Dean John Jeffries of the University of Virginia Law School. It's also an honor to have in our audience today Mrs. Mimi Gronlund, daughter of the late U.S. Supreme Court Justice Tom Clark, and her daughter Julie, a Charlottesville resident. A special welcome goes to our guests from Westminster, Canterbury, and all of those attending the Virginia Festival of the Book, sponsored by our good friends at the Virginia Foundation for the Humanities. Finally, I would like to thank Bob O'Neill, the founding director of the Thomas Jefferson Center for the Protection of Free Expression, for kindly providing a supportive home for the lectureship. We also want to thank him as well for serving on the advisory board of the Virginia Law-Related Education Center, which co-sponsors today's program. Our gratitude also to Josh Wheeler, who is Director of Programs at the Thomas Jefferson Center, who helped to organize this afternoon's event, along with his colleague Amy McClung and our colleague Chris Ogden, the former coordinator of ValRec. Before I turn the podium over to Bob O'Neill for the introduction of our speaker, I want to say how delighted I am to have Joan Biskupic with us as the 8th Abraham Distinguished Lecturer. Joan's coverage of the Supreme Court has certainly been a boon to my own research, and I commend to you her new biography of Justice Sandra Day O'Connor, which is as interesting, thorough, and inspiring as its subject. And the book is available out in the lobby this afternoon, and Joan will happily inscribe those books after the talk today. And so, Joan, thank you for your enthusiastic acceptance of our invitation. Now I turn the podium over to Bob O'Neill for formal introductory remarks. Thank you all for being here.
Thank you, Barbara. By now, I suspect most of you have figured out we are not in the law school. I should say that the law school is more than 150 years old. We welcome our newer neighbor next door. I should also point out that we too have many successful and affluent alumni. We just display the product of their generosity in slightly different ways. But we are delighted by the hospitality that the Darden School has extended to us this evening as evidence of the kind of interaction that occurs in a large and complex university. Once again, we gather to honor two people. Barbara has already given us once again a sense of why Henry Abraham is the perennial honoree of this event. As the two vacancies occurred on the Supreme Court, one might have wondered, would the news media once again seek Henry's guidance and counsel in the nomination process? And of course they did. And it is consistent with that comment that I noted recently, in which one columnist described Henry's justices and presidents as in the columnist's words, indispensable work on the subject. So, as the years go on, Henry persists in the successful but unauthorized practice of law. And we are delighted by his continuing success. This evening, we also welcome and honor someone who has for many years been a follower of Henry Abraham's work and has put his teachings and insights to admirable use. Very soon after I came to Virginia, I had the first of many conversations with Joan Biskupic, usually about the work of the United States Supreme Court and a currently pending case, although occasionally taking a somewhat longer perspective and a larger view. Early on, I came to appreciate, as one can only do behind the scenes, the extraordinarily careful and conscientious preparation that contributed to, at that time, the Washington Post's and later USA Today's coverage of the Supreme Court and its rulings. To have, as we do this evening, the privilege of sharing her insights in person, that's a rare treat to which I must confess I have been looking forward for many months. A graduate of the Universities of Oklahoma and Marquette, she received her law degree from Georgetown. She first reported about legal affairs for the Congressional Quarterly before joining the Post in 1992 as its Supreme Court expert. The year before that, she'd received the Everett McKinley Dirksen Award for distinguished reporting of national affairs, that on the basis of her extraordinary coverage of the Clarence Thomas confirmation process. She's also written several legal reference books, including Congressional Quarterly's 2-volume encyclopedia on the Supreme Court. It is, however, a much more recent work that brings her here this evening and makes her presentation a most fitting part of our annual Festival of the Book. While she served as a fellow at the Woodrow Wilson International Center for Scholars, Joan Biskupic undertook research on the career and the impact of Justice Sandra Day O'Connor. The resulting book was published last fall with the intriguing subtitle, How the First Woman on the Court Became Its Most Influential Justice. The book has been widely acclaimed, has been the focal point of a number of university and other forums, such as this one this evening in Charlottesville. The importance of the subject has only intensified in the months since the book appeared. Indeed, I have the uncanny feeling that Joan Biskupic not only anticipated Justice O'Connor's retirement from the court, but she also sensed that a change in status would liberate the justice and enable her to speak more freely of matters at which she could only hint during her many years on the bench. We are now, I think, beginning to appreciate Justice O'Connor and her legacy even more clearly and deeply than at any time during her years on the court. And providentially, we have with us this evening the person who can best underscore and reinforce that appreciation. Delighted to welcome Joan Biskupic as the 8th Henry Abraham Lecturer.
That was wonderful. Thank you very much. Thank you, Barbara Perry and Bob O'Neill. As Bob said, I've had many of these events lately, but I just feel so welcomed by both of you and so honored by this award and this lectureship. Thank you so much to Professor Abraham. I'm glad to meet his wife, Mildred. I'm so glad that General Souter and his wife, Jeannie, and Lynn came from the court. I want to welcome all of you who came in the name of Professor Abraham, but also those of you who came as part of the Virginia Festival of the Book. I do want to mention, Bob, that I didn't anticipate her retirement in some ways. In fact, on July 1st, I thought I was subject of an extensive practical joke. But I'll talk more about that during the Q&A. After I give I always like to hear your questions, so we'll leave time tonight for those, and also for those of you who would like me to sign your books. It is fitting to be here talking about Justice O'Connor in the name of Professor Abraham, because years ago, I read a statement in one of his many books that he attributed to her. And that statement rattled around in my brain and actually was part of what persuaded me to do this book. And here's what it was, and it'll be very familiar to you and to Barbara, I'm sure. And this is what Justice O'Connor said. While there are many supposed criteria for the selection of a justice, from the nominee's viewpoint, it is probably a classic example of being the right person in the right spot at the right time. What my book does, and what I'd like to address today, is to talk about how Justice O'Connor became that, quote, right person, and in the context that Professors Abraham and Perry will recognize, one that is so attuned to the political history of appointments. Sandra Day O'Connor's place in history was set in 1981, of course, when she was appointed by Ronald Reagan. She broke a 2-century tradition of men only at the nation's highest court. Until her appointment, no woman had ever sat in the private conference room where the justices decide what cases to take, and more importantly, how those cases should be resolved. And then her childhood on the Lazy Bee also gave her a distinctive character compared to her colleagues. That durable work ethic certainly was on display during these past 7 months that it took for George Bush to fill her seat, and she stayed on. But the part of Justice O'Connor's character that really set her apart during her nearly 25 years on the bench is her political experience. One of the major theses of my book is that Justice O'Connor came to the Supreme Court knowing how to count votes. And that had large consequences for the court's rulings. Now, of course, we've had politicians on the Supreme Court before, but for her nearly 25 years on the Supreme Court, she was the only former elected politician sitting there. From the beginning, she knew how to watch the masters such as William Brennan, the 1956 appointee of President Eisenhower, who was legendary in his ability to round up 5 votes for a majority ruling even after the court had become very conservative. She learned to monitor the views of wavering justices and to take a leading role in crafting consensus. Now, her methods, which had their basis in her legislative experience, were not unique, but they were more constant and more effective and more intense compared to the other justices during her 25 years. A note that Justice Brennan sent to Thurgood Marshall in 1990 also started me thinking about this book and thinking about O'Connor more in terms of her ability to strategize. And that Brennan note, written in a criminal case, said, "As you will recall, Sandra forced my hand by threatening to lead the revolution." And that, I'll explain more about that note as I go on, but that really got me thinking about her as not so much as just this mere swing vote or this person who had an uncanny ability to craft consensus, but somebody who was really giving Bill Brennan a run for his money. I thought for an audience like this, it would be best to illuminate Justice O'Connor's methods in particular cases, how she worked to bring about certain rulings, and as I say, got Bill Brennan's attention. In fact, one of the things I do is I trace the relationship between Justice Brennan and Justice O'Connor, and I believe that he, above all of his colleagues, really sensed early on the kind of force that she could be behind the scenes. But I want to first offer an example from her political life as a state senator in the early 1970s. I think this illustrates what kind of experience she brought to Washington that was distinct from her colleagues, just like her Lazy Bee experience, just like her experience as a woman was distinct. In the fall of 1971, when Sandra Day O'Connor was in her second year as an Arizona senator, President Nixon happened to have two openings on the Supreme Court, arising from the ill health and retirements of Justice John Marshall Harlan and Hugo Black. Now let's all go back to the fall of 1971. Women's groups then, this is a decade before Sandra Day O'Connor is going to come on the court, women's groups were clamoring for the first woman justice. Gloria Steinem was founding Ms. Magazine. The ACLU was starting the Women's Rights Project, led by a woman by the name of Ruth Bader Ginsburg. Even Pat Nixon was saying that she was pressing her husband to appoint a woman. And in Arizona, State Senator Sandra O'Connor expressed similar interest. She wrote to Nixon about it. I found a letter that she penned from October 1st, 1971, and she says to the president, "It is my belief that the citizens of this nation would warmly accept appointment of a woman to the Supreme Court." She goes on about how there was a woman on the Arizona Supreme Court and everything was okay there. And then, but then she closes in this great way. You know, this is, of course, in October 1st, 1971. She says, "Thank you for all the good deeds that you're doing, and I think Warren Burger was a terrific chief." So, you know, she already had her tone, and she signs it Sandra O'Connor, State Senator, Arizona. Well, Nixon had forwarded the name of Mildred Lilly. I know that's familiar to you, Professor Abraham. Mildred Lilly, a California state judge, along with the names of 5 other potential nominees to the American Bar Association for screening. Another name was Senator Harry Byrd. But anyway, he sends these names, but the Oval Office taping system that would become infamous during Watergate picks up Nixon's true sentiment about the idea of a woman. Robert Byrd. Did I say Harry Byrd? See, I'm back so many generations of these people. I keep calling the current senator Birch Bayh also. But anyway, Senator Robert Byrd was on the list with Mildred Lilly, this little-known California state judge, but she happened to be a woman. And President Nixon is saying, "See, I'm sincere about maybe wanting a woman on the Supreme Court too." But the Oval Office taping system that would become infamous during Watergate picked up Nixon's true sentiment about appointing a woman. And he says, "I'm against it, frankly. I don't want any of them around." And then he says, "Thank God we don't have any in the cabinet." But then in classic Nixon style, he adds, "The cabinet's so lousy, we might as well have a woman too." I have to say that one of the most terrific things, I was talking to several people here who have been librarians and archivists about how much fun I had going to libraries and archives as I did this book. But one of the most wonderful things is to go to the College Park archives where the Nixon tapes are held, and you can bring your little tapes from CVS in there and copy them. And I was riding around Washington, D.C. listening to Nixon talk like this, which was great. But anyway, there's wonderful conversations that Richard Nixon is having with Warren Burger about who to put on the court. And at one point, he says, at this point, Lewis Powell was sort of weighing it, but he was worried about being old. And President Nixon says, to Warren Burger, "How hard is that job? They don't work very hard." And Burger says, "Well, they don't, but I do." Anyway, they're wonderful to get. They're wonderful to get. Now, the ABA rates Mildred Lilly poorly, which gives Nixon some political cover to drop the possibility of a woman appointee. And on October 21st, 1971, President Nixon goes on national TV to announce the nominations of Lewis Powell and William Rehnquist for the Black and Harlan seats. Now, O'Connor happened to be at a meeting of the newly formed Phoenix Historical Commission that evening. And I got the minutes of the evening. I got to talk to people who were actually there that October 21st. And it was a much smaller room than this, but it was not unlike a setting where you're sitting there. And of course, they were on folding chairs rather than those comfortable chairs. And what happens is the mayor of Phoenix is giving the charge to this historical commission. It happened to have been the 100th anniversary of Phoenix. and all these good citizens, O'Connor was always at the lead of that, were there to talk about how to get the history of Phoenix down and start a new historical museum and commission. And an aide to the mayor comes in and hands him a note. And the note says that Nixon has just nominated Bill Rehnquist. Well, this is big news to all of them in this room. As many of you know, Bill Rehnquist was born and reared in Wisconsin, went to school at Stanford, but he had adopted Phoenix as his home. And so most of the people in this room, notably Sandra O'Connor, knew Bill Rehnquist, and they were thrilled. He had come to Phoenix in the 50s, as she did, to start practicing law and to raise a family. So at this historical commission meeting, she immediately expresses great enthusiasm for her old Stanford law classmate. The next day, she goes to the floor of the Arizona Senate and describes Rehnquist as one of the most brilliant legal minds in the country. She talks about how she knew him at Stanford and how he was head and shoulders above everyone else. And then she predicts that because of his young age, 47, Rehnquist might someday be Chief Justice. But she did not completely abandon the position that she took in her October 1st letter to the president, and she quips to senators that she regretted that the nominee doesn't wear a skirt. But whatever misgivings Sandra O'Connor might have had about Nixon's choice, they were put aside as she immediately launched into action for Rehnquist, who had left Phoenix in 1969 to join the Nixon administration Justice Department as an assistant attorney general. What she does then at this moment, and this is why I say I felt that this incident in her life was so revealing for her methods. She calls up Stanford, and she has them send to her huge computer printouts. Remember, this is the 70s, so that, nobody's emailing anything. Huge old computer printouts of all the Stanford alumni from her year and years adjacent to their 52 graduation. And she goes through this. Now, Stanford at this time is really becoming a powerhouse of its own, and a lot of the alumni of the law school are quite prominent. So she divvies all these names up. She was the queen of Post-its before there were Post-its. In her files at the Arizona archives are all these little slips, little to-do lists of what she's going to do, but also what the mayor's going to do, what her husband's going to do. So she had divided up all the names on these Stanford alumni lists and had them call senators to say, Bill Rehnquist is wonderful, you have to vote for Bill Rehnquist. She urged these prominent alumni to write. She wrote letters to senators on his behalf. She met with the newspaper editors. She got articles written. She spoke out. She had this platform of always herself going to Kiwanis Club meetings and all this. And she was talking him up to everyone. Now, she needed to a bit in Arizona because civil rights groups in Phoenix especially were against Bill Rehnquist. He was definitely not a well-known name in America in fall of 1971, but those who knew him were suspicious of him. In Phoenix, he had protested a 1964 local anti-discrimination ordinance and testified as a private citizen, not even as any kind of office holder. He had testified against a 1967 school desegregation plan. As a Nixon lawyer then, he was essentially the face of wiretapping and actions against Vietnam protesters. The one thing I have to say about Bill Rehnquist, he was never shy about expressing his views to Congress. He was the one who would go up and testify and say, yeah, we need to crack down on protesters. Yes, we need more ability to do wiretaps and surveillance. So he had a lot of liberals and Democratic senators against him. Now, while she was not troubled by his record, but she knew his record could be trouble. And I found this one, she was constantly writing to him in Washington, and I found this one package of clippings that she sent to him that had some articles that he had written for the local paper about that bleeding heart Supreme Court that's always letting criminals off on technicalities. And she writes this little note that says, so far the press hasn't seen this yet. It would be best if it didn't come out. So she sort of knew what he was up against, and she drew up a list of senators who, based on their records, would probably be against them, and she kept track of what they were saying. So fortunately for me, her archives in Arizona had only recently been opened when I started working on this. Well, at some point, Bill Rehnquist recognizes what she's doing, and he writes to her in November, about 3 weeks after he's been nominated, on Justice Department stationery. He sends her a letter that says, words are inadequate to convey my appreciation for what you have done for me in connection with the nomination to the Supreme Court. I feel that a very effective organization has somehow been suddenly called into being largely as a result of your doing. Now, more than 3 decades later, I'm having lunch with Bill Rehnquist in his chambers. Because I'm from Chicago, I always played the upper Midwest card, we're together, right? And he was wonderful. He really gave me a lot of access, and when I set out to do this book, I said, I can't write about Sandra Day O'Connor without tripping over the young Bill Rehnquist. Can I come see you? And the Chief Justice said yes. And I told him some of the things I found, and I said, do you remember all this? And he said no. he said he did not recall O'Connor's involvement. Mainly, he remembered the controversy in Washington. Of course, Burt Bye of Indiana and Teddy Kennedy of Massachusetts were leading the opposition to his nomination. Some of you might remember Joe Rao of the Leadership Conference on Civil Rights, who was quite active against him. Lots of people who were more formidable and who had larger roles to play were on his radar screen rather than Sandra O'Connor in Phoenix. But he ends up being approved by the Senate 68-26. And when he's sworn in on January 7th, 1972, as an Associate Justice, Sandra O'Connor is there. And his investiture marked the first time that she was ever in the courtroom. So she returns to Phoenix after this, soon becomes Nixon's 1972 re-election campaign chief, co-chairman in Arizona. Then she's elected Arizona's Senate Majority Leader. Then she becomes a state trial judge, then an appeals court judge. But before Sandra Day O'Connor closes the chapter on Rehnquist's appointment in 1972, she gathers up all the copies of the letters that she sent and that she solicited, her personal score sheet of what the senators did, their remarks, and stacks of newspaper clippings, and she files them into several large folders. But she also puts in a cartoon that she found that had run in November 1971 in the Arizona Republic. And in that cartoon, a disheveled but grinning man is looking into a hospital nursery window at his newborn daughter. Remember that cliche of the father holding the flowers, looking at the nursery at his newborn daughter, as if he had nothing to do with anything until the daughter was delivered. And the man says to the nurse at his side, "Just think, she might someday be a Supreme Court justice." And she saved that. And she saved that in her files, and it endures till today. Well, once on the court, after her appointment by President Reagan in 1981, O'Connor learned to work both incrementally and broadly. All of the members of the Supreme Court bargain with each other to various degrees. It's part of the process of putting together an opinion. It's part of that collective, collaborative process that produces a majority opinion, which they have to produce. But O'Connor, the former legislator, was particularly suited to the kind of give and take behind the scenes. Further, her efficient manner really helped her keep her eye on several balls at one time, multiple topics, multiple cases. She was able to have a hand in cases in a way that really not many justices at that time were able to do, as I have been able to figure out from looking at many of the justices' papers. And she had a real competitive nature that made her want to win. We all think of her as not just the first woman on the court, but also the sportswoman on the court. I mean, this is a very competitive individual who I don't think really felt like she needed to take control of certain areas of the law, but once she got invested in something, she was quite invested and worked very hard to have things come out her way. And in her negotiations with other justices, she often accentuated her state legislative and state court experience. In one 1984 case that I tracked, she invoked her tenure as a trial judge to persuade Lewis Powell to change his vote and to reinstate the murder conviction of a Pennsylvania high school teacher who had strangled a student to death. This sensational case had dominated the news in rural Clearfield County, Pennsylvania in the 60s. A man by the name of John Yout had been convicted after a trial of this murder of this student, but an appeals court reversed, finding that this so-called confession had tainted the jury, and it had been obtained. The confession had been obtained in violation of his right to counsel, and then news of it had tainted the trial. So he has a second trial, and he has another conviction. But then a federal appeals court reverses that conviction too because of reports of his confession and earlier conviction supposedly tainted the jury pool also. So here we are at the Supreme Court with the state of Pennsylvania appealing, saying we want to have this guy's conviction reinstated. It's been going on for nearly 20 years. And we've got like a divided court. Justice Thurgood Marshall wasn't participating in this case. There was a divided court, and it looked like Joan's conviction was going to be thrown out and then affirmed by the Supreme Court by a divided court. But she writes to Powell, "Forgive me for sending you another letter, but I always write to you because you're so willing to listen and because it seems most unfortunate to resolve this case by an equally divided court. I hope you might be persuaded to consider a reversal." She goes on to Powell to say that the colloquy that the judge in this case had reminded her of colloquies that she had heard when she was a judge talking to jurors. And she goes on about how prospective jurors aren't lawyers. They sometimes say things they don't mean, and this juror probably wasn't as tainted as the appeals court thought he was by the earlier news reports. And then she says, "It's easy for us, 14 years after the trial, to detect awkward statements and to, in effect, second-guess the judge. But the trial judge was there, and I know what trial judges hear, and the trial judge expressly denied the challenge for cause because he believed the juror would be fair." Well, what happened next, I believe, demonstrated the kind of effect that Justice O'Connor could have on Justice Powell. He not only switches his vote, he takes over the opinion for the court, and he reverses the judgment that had favored this John Young defendant, gets it reinstated, and he's still in prison. But the correspondence that I found, as I was telling some people earlier, mostly found in the Lewis Powell archives at Washington and Lee, was so invaluable to me because I could see how she was working. And then when I would look at the Thurgood Marshall files and the Harry Blackmun files, and I also had special permission to get into the William Brennan files, I could see how she was maneuvering in ways that the other justices didn't realize. She often would go to somebody personally, and she did a lot of between you and me, or remember my legislative experience, not in any way that I think presented a false front, but in ways that made good use of her own personal experience that the others didn't have. In an episode the following year, in 1985, O'Connor helped Lewis Powell wrest the majority from William Brennan in a First Amendment case. One note she sent revealed her approach. Now this case, again, it wasn't a real big one. It was called Dun and Bradstreet versus Green Moss, and it was a libel case. And she writes, "This case has been making its uncertain way through the court for 2 terms now. I'm not sure the court will succeed in resolving it in any way that I regard as satisfactory. But something has occurred that offers the possibility that 4, and perhaps 5 of us can partially agree on a significant feature. Byron has showed me a rough draft of his proposed opinion," Byron White. "He is not planning to join Bill Brennan." Now at this moment, as I compared correspondence among the justices, Bill Brennan still thinks he has a majority in this case. He thinks Byron White is with him. But Justice O'Connor had sensed tentativeness on Byron White's part, had gone to him, happened to be over a Christmas break, had talked to him, and had realized that Byron White was ready to pull his 5th vote away from Bill Brennan. So she says to Lewis Powell, "He is not planning to join Bill Brennan, so there are potentially 5 votes in opposition to the circulating majority opinion. This is reason enough to make it worthwhile to pursue every avenue of agreement among those of us in dissent who might thereby become the majority." Now the final decision, Powell gets it, through maneuvering. In fact, there's a very touching set of correspondence between Bill Brennan and John Paul Stevens, who at this point are on the same side of this case. And Brennan is saying to Stevens, "I think something's up. I think I need to work harder on Byron White. Do you think I should do this and this and this?" And this case actually stemmed from New York Times versus Sullivan, so this was Brennan's baby in a lot of ways. He really wanted to win this case, even though it was not half as significant as New York Times versus Sullivan. But Stevens says to him, "No, I think things will be okay, and just don't overplay your hand on on some of the precedent, and Byron should be with you." But the truth was, by the time they even had that correspondence, it was about a month and a half after Justice O'Connor had written to Lewis Powell to alert him to Byron White being ready to switch. In the final decision enhanced the ability of some individuals to recover for libel in commercial situations. Justice Brennan himself had said the facts were idiosyncratic. It wasn't that big of a deal. It didn't make a lot of headlines back in the mid-'80s. But I use it to show how it revealed how Justice O'Connor could take a page from Brennan's own playbook and build a majority. I found that in several cases where she negotiated behind the scenes, you wouldn't have known it from the ruling that came out. She didn't write a concurring opinion. She didn't have the majority opinion. She let herself stay in the background. She didn't feel the need to toot her own horn. But in time, Justice O'Connor became particularly adept at parlaying her negotiations among the justices into separate concurring opinions. And this would be where much of her legacy would rest. An affirmative action case in 1985 presented the perfect opportunity for her to use that power of concurrence. This will be familiar to some of you. It was the Wygant case from Michigan that had significance because it leads in part to the 2003 ruling in the University of Michigan affirmative action case. In this situation, white teachers were laid off to preserve the jobs of some black teachers with less seniority. The whites had been let go as part of the policy of a collective bargaining agreement that shielded the blacks from being let go just because of the importance under the collective bargaining agreement of having black teachers as role models in this district. And lower federal courts had ruled the deal permissible, and here were these white teachers appealing to the Supreme Court. Now, Justice O'Connor believed that remedial programs could be imposed, but only for limited periods. And but she also, she was hesitant, and she admitted that she really had a limited sense of the minority experience. She once wrote, "Like most of my counterparts who grew up in the Southwest in the 1930s and 40s, I had not been personally exposed to racial tensions before Brown versus Board of Education. I had no personal sense of being a minority in a society that cared primarily for the majority." So she, as many of you know, she really had a hard time in this area and really did try to figure out if there was a way to cut it down the middle. After the initial vote on the case, 4 justices were against the board's affirmative action policy, and predictably they were Chief Justice Warren Burger, Byron White, Lewis Powell, and Bill Rehnquist, and 4 favored it equally predictably: Bill Brennan, Thurgood Marshall, Harry Blackmun, and John Paul Stevens. So when the vote, as many of you know, they're in conference and they vote by seniority, and here in the mid-'80s, she's still the most junior justice, so you've got a deadlock of 4-4. Vote comes around to her, and she says, well, I'm not sure what I want to do. I'd rather just remand it, have the lower courts look at it more. And after this vote, Justice Blackmun wrote in his little notes that he always kept during these meetings, tentative, exclamation point, exclamation point, exclamation point, and he went back and said to his clerk, he kind of mocked her a little bit, and he went back and he said, this is what Sandra did. I vote tentatively, very tentatively. But anyway, it served her in some ways with this group because it was such a polarized court. But Chief Justice Burger presumes that she will end up on their side, so he gives the opinion to Lewis Powell to write to try to win over her vote. Meanwhile, Thurgood Marshall is writing for what might be the dissent, indeed ends up being the dissent, but he's trying to win over her vote too. And Powell is making all these entrees to her, saying, he says at one point, it's obvious that I need your vote rather badly, which he does. He needs her. And at one point, he even told her that he regretted that he had not signed her opinion in Mississippi University for Women versus Hogan, which was the case of a male nurse who wanted to go to a state-run school. And it was one of her very first cases on the court, a 1982 case where Justice O'Connor wrote for the majority, joined by the more liberal justices, that Mississippi state-run school couldn't exclude men from this nursing program. She said it was based on stereotypes that only women could be nurses. And Lewis Powell at the time had said, why would any man want to be a nurse? And he was in dissent, and he was quite strong. He felt that this was sort of corrupting the idea of certain roles, but he had come around by in a few years, and he writes her a very tender note that says, I wish I had joined your opinion then. And several of his notes to her convince her to sign enough of his opinion to invalidate the layoff of the white teacher in Wygant versus Jackson Board of Ed. But she wrote a separate concurring opinion spelling out her rationale for when government could use affirmative action. And once legal analysts, once law professors and newspaper reporters saw her opinion on that morning in May 1986, attention shifted away from Powell's majority, away from Marshall's dissent, and her opinion became the key one that editorial pages focused on. Because what she did was she articulated certain core principles of when you could use affirmative action to remedy past discrimination as long as it didn't unnecessarily hurt innocent individuals. And she was one of 5 justices, this is where she swung over to the liberal side, who rejected the broad position that the Constitution bans government from using any kind of racial preferences in employment. And just to bring us all back to the mid-'80s, this was something that was very important to the Reagan administration. The Reagan administration was trying to end affirmative action in a big way, so her opinion really made a difference. She had limited it to the facts in the Wigand case and signaled that she wouldn't oppose all race-based measures. And this was important for the mid-'80s, but it was also important when we all come up to nearly the present time in 2003, when Justice O'Connor becomes the swing vote to say that the University of Michigan Law School can continue to consider race in its application process. And she picks up a page from that Wigand concurrence from 1986 that allows her to take that position. Now, I had an interview with Justice O'Connor years later in which I asked her about this Wigand case from Michigan. It was early 2003, before her ruling in the June University of Michigan case, and before I knew what she was going to do. But I asked her about what I had seen in the behind-the-scene papers in this case from Michigan from years ago. And what she said was, "We all have a strong voice here. It is the strength of the reasoning that matters in each case." And then she rejected any suggestion that she was navigating the middle in any strategic way to bring the justices together. But I believe that it was her ability to work the middle and in her concurrences that are a part of the legacy that she now leaves us. In affirmative action, in other race-based policies, on abortion certainly, on religious displays in public places, you know, it's her test that we're all living under, and on the division between federal power and state power. I did not intend to write the last word on Justice O'Connor. In fact, until the end, I did indeed think that she would still be on the bench when this book was finished. I'll just throw in here that on July 1st, when she announced, and you know, I got a couple calls from some friends at the court who said, I'm pointing at you, Bill, but I know you weren't the one who tipped me off, who said, it's her, she's leaving. And I kept saying, she'll never go, you know. But you know why I thought that? Because I had known of her husband's health condition. I had seen her handling it, and I thought, she's so can-do. But you know what, it was this darndest thing. When I went back and read what I had written, which was the whole book that was almost done, I had almost foreshadowed it because I had been weaving in John's life and her husband John's life. I've been weaving in things that she had said and done. But I was in some sort of denial mode, as were several of her colleagues. Justice Scalia told me, I heard about it on the way into work that day. You know, and Justice Ginsburg and Justice Breyer had just said, she'll never go. And I think a lot of people just believed that this was one can-do woman. But anyway, as I was writing this book, I thought, well, we'll still hear more from her. But now, of course, that she is finished on the court, the question is, what of her writing will endure? We will see in upcoming years whether the, quote, strength of her reasoning, the phrase she used in our interview, is carried on with the newly reconstituted Roberts Court. Then we'll see. Thank you all very much. And what I'd like to do now is take questions. We've got about 5 or 10 minutes if anybody wants to ask about. I actually interviewed all the justices but one. In fact, it's interesting that Tinsley Yarborough is here because he has used David Souter as one of his subjects, and David Souter was the one justice who would not sit for an interview. The others sat. Most of them agreed to be tape recorded, which was really unusual for them. And he kept writing to me. I kept writing to him. He kept writing to me saying, no, I know the rest are doing it, but it's just really against my principle to sit. And actually, Tinsley, I thought it was because of you. I thought because he was being subjected to a biography, he might not want to expose himself. But a very good biography of Justice Souter in his book. Yes, Barbara?
Joan, can you elaborate a little bit on the relationship between Justice O'Connor and Justice Brennan? Because I always think of them as two of the most engaging, lovely personalities on the bench. And so I was a little bit surprised in your book about what seems to be a genuine tension between the two of them.
Yes. You know, think of Justice Brennan. He was born, you know, right after the turn of the century. He was really kind of a man's man in some ways. He liked to link arms. He liked to say, hiya, pal. He sort of, I think he didn't know sort of what to make of Justice O'Connor. for as much as he did for women's rights through his writings, as some of you know, he was really late to hire female clerks. It didn't come naturally to him to sort of think of her as an equal, frankly, and also he was suspicious of her as a Reagan appointee. I found this one incident that law clerks at the time didn't know about, but all the justices did. It's just about 3 months after she's come on the court. The court in the early 80s had a huge caseload compared to now. They were hearing 2 arguments in the morning, 2 arguments in the afternoon, probably about twice the number of cases on their schedule to be resolved. And Justices Berger and Rehnquist were trying to figure out ways to lessen the load. And they suggested to Justice O'Connor, who then proposed the idea, that they actually resolve some cases without oral argument. And she sent a note. She's, this is pretty bold of her. She's only been on the court since September, and this is in December of '81. She writes a note to Chief Justice Berger and the rest of the conference that says, I think we should dispense with oral arguments in some cases, just decide them on the briefs. Kind of a radical proposal, given that the court had always heard oral arguments. And Justices Rehnquist and Powell say, well, maybe, Justice Rehnquist says, yeah, this is a good idea, I proposed it myself. The Chief Justice likes it. Powell and Stevens say, well, let's think about it. Justice Brennan writes back immediately saying, I could not disagree with Sanders' proposal more, and he's underlining more. And he said, when I was in New Jersey, that state Supreme Court was so corrupt, and one of the reasons it was corrupt is that it decided cases without hearing oral arguments. If Sanders' proposal is adopted, I will go public with my dissent. And he came back kind of in a nuclear fashion, not saying, well, let's kind of talk about it. And I think he was suspicious of her, but they were both smart enough politically, and they were both decent people. They're not quarreling in any way around the conference table, but they both knew that they needed each other's vote. But there was definitely tension between the two that emerges in the correspondence. But she was shrewd. She watched him, and he watched her. Yes. Justice O'Connor in the last 2 years has made a priority of the idea of the independence of the judiciary. She's now in retirement going to be working on a commission on that. This was something that's so typical. Justice O'Connor, she invited DeLay and some of the House members over for lunch one day at the court, kind of smooth relations, which frankly was another reason why I thought she might not be quitting, because she seemed to take this on as a new project. She had given that speech to the Appellate Academy in November, the same speech, what she says, just to clarify what she says about where America could be sliding, she talks about how Zimbabwe is a dictatorship and how judges aren't free to decide what they can decide, and that nobody is always aware of the first step toward a downward slide, and that we should pay attention to these kinds of criticism of judges, because once judges feel impinged in any way or that their rulings could have political consequences, we could end up in a place we don't want to be. I think that we're going to hear her be more outspoken. She certainly has a platform. As I say about Justice O'Connor, she never says anything just off the cuff. She always knows what she's doing. And I think that she will, she's a very vigorous, she's turned 76 on Sunday. She will turn 76 this Sunday, the 26th. And she's a very vigorous 76-year-old. I think we're going to hear a lot of her. Yes, sir. Oh, ma'am, sorry. I can see you now, yeah. Well, it's interesting. I almost brought that up when I mentioned her competitiveness, because I'll have to tell you what happened after that decision and when she got so much complaint. Right after the election, like the day after the election, she happened to have had a bunch of Arizonans in where she did what she always does, is she cooks. When she was young, she entered cooking contests, and she still likes to cook a lot. So she was cooking for a group of Arizonans. Probably would have been like, 36 hours after the election was actually held, and we don't know what's going on. Florida has, gone back and forth. And her brother happens to be in the group and he says, Sandra, don't you think this case is going to get to you? And she says, no, it's a state court matter, it's a state matter, it's a mess though, and they better clean it up. And that was kind of her view from the start, is that The ballot counting she found to be very problematic. She and Justice Kennedy were very influenced by those scenes that we saw playing out on TV where people are like, looks like a vote, looks like a hanging chad, you know, who knows. And her vote never wavered on that. She believed that the Florida Supreme Court had overread interfered with the legislative mandates of having these deadlines and having standards in vote counting. She felt like the county by county differentials were a very bad thing. But she was frankly really thrown by the criticism. She was surprised at the outpouring of complaint. I felt that it would have been helpful if she had written an opinion, because she was in normal other situations good at kind of laying out why the court did something, why it didn't. But after that ruling, she goes back to Arizona. Her chambers has been deluged with, you know, thousands of letters of complaint. She's gotten complaints at her home. She's gotten complaints everywhere. She goes back to Arizona for a little R&R, plays a game of golf, and that was when she hit her first hole in one. So it was sort of like, you know, all right, I'm going to regroup there. You know, when you asked about her relationship with Justice Brennan, a couple people have asked about her relationship with Justice Scalia, which also had its tensions. And one of my chapters is called Scalia versus O'Connor. And I was lucky enough to talk to Justice Scalia about what he makes of her. And of course, he and all his colleagues said, you know, look, even though we argue about things, even though we dispute legal rationale, we really do get along. And he told me a great story about the first time he had met her, or at least had actually gotten to know her a little better. He was still on the Court of Appeals for the District of Columbia Circuit, and she was already a justice, and it was on one of these Anglo-American exchanges over to London. And if any of you have ever dealt with Justice O'Connor, you know what a clock she runs on. And you know, if she says you be at the bus by 8 o'clock, you better be at the bus by 8 o'clock. So they had gone to, you know, Buckingham Palace or something. They had gone to see one site, and she says to all these lower court judges and her colleagues from the court, okay, be back here at 10 to 8, and then we go on to our next stop. And as Justice Scalia says to me, I was like 2 minutes late. And he said, and I see her, and the bus is pulling away, and I'm waving my coat saying, wait for me, wait for me. And he says, that's when I learned, don't mess with Sandra. But the truth is that he has messed with her in print plenty. And I asked, Justice Ginsburg had a great line. She said, you know, I just love Nino, but sometimes I'd like to strangle him. And what they all basically said was, look, you know, he's sort of our Nino. We all get along. We close ranks, and that all of them who I interviewed said, you know, there are plenty of times that we think what he said has crossed the line, but you know, that's him. Okay. Yes, I can. Oh, there, I see. Okay, the lights are a little tight. Okay. I think that's a good question, especially since we're now going to see more tensions between the executive and the judiciary next week in a military tribunals case. You know, there's just a lot going on right now, from what Bob O'Neill mentioned about, you know, the independence of the judiciary, and you know, some of these social issues like you mentioned with same-sex marriage. This is what I think she believes from how she's ruled and what she said. She really believes that social policy is the domain of the elected branch. That, you know, state legislators, people who are sent to their state capitals, people who come to Washington, they're closer to the people. They know what the people want. So she starts with that idea on issues like abortion, issues like you know, same-sex policies. But those are things that should be worked out. You know, assisted suicide, those really tough hot-button issues. She has written a lot about how, you know, states, you all have first crack at them. But when it comes to disputes among the branches and having a strong judiciary, I think she would very much protect the prerogative of the judiciary. That she believes, you know, when you think of her line in the first set of anti-terrorism cases where she said a state of war is not a blank check, she really sees an important role for the judiciary to be certainly a check on the executive branch and on the legislative branch too in many ways, but I think especially on the executive branch. And she rules so narrowly and so incrementally that it's hard to make other statements beyond those kind of generalizations, because everything to her is so fact specific that if she were sitting there now and the military tribunals came up, you know, I'd really have a hard time predicting what she would do, despite what she said in this Hamdi case from 2004, where she wrote her famous line about a state of war is not a blank check. So I think it's a good question, and I think really the court right now is up for grabs, given the new Chief Justice, who's so dynamic and so persuasive, and Samuel Alito, who we don't know how he's going to rule, but his background certainly suggests that he would be slightly to the right, at least, of Justice O'Connor, who became more moderate.
Well, because Henry runs on the same clock as Justice O'Connor.
Okay.
We're all so close. Let's thank Joan one more time for being here.
Thank you.